I find the submission from Facebook to the committee this morning really disappointing. The proposition in the legislation is incredibly modest. All it is saying is for the 3 or 4 weeks of a general election campaign, election ads or ads that are designed to have an impact on the electoral outcome should be designated as such. Information about the way in which those ads are being targeted and funded should be made public, and there should be some responsibility on the platform who publishes these ads to take responsibility and ensure the advertiser is compliant with the law. They're really basic propositions. And the idea that Facebook would come to the committee and try and water down already a very weak proposal, I think is concerning, and I just want to put that on the record. I do agree that we need to make sure that the definition of political advertising is got right, and NGOs and the Irish Council of Civil Liberties have highlighted that. But I don't see how your definition addresses any of those issues. In fact, your subsection 3 would include most of the areas where NGOs and human rights organisations would seek to be able to advertise on. So I suppose my first question is, how do you see your definition as outlined in Annex A to be better than the government's, i.e. what could the government's capture that yours doesn't? That's my first question. The second thing is, I don't see anywhere in the general scheme where there are data protection concerns. Nowhere does it talk about anybody's home address. It does talk about a name and postal address. But for example, as election agents and election posters often do, they'll use an office address, or some of us would have used our county council addresses when we were elected councillors. So in the same way as candidates and or election agents their information is made public, I don't see why it shouldn't be the case here. Likewise, for example, I mean, you make a spurious argument around comparing the fact that the regulations around postering are different and less onerous than micro-targeting. But for example, when a candidate spends 5 times more money on posters than anybody else, we see that. We see the posters up on the streets and on the lampposts, whereas there isn't public visibility on micro-targeting. So I don't see how that's a valid concern, and maybe if you can speak a little bit more detail to that. My biggest concern, of course, is your comments in relation to Head 122, because you seem to be suggesting that rather than Facebook having a responsibility to ensure the people who place ads on your platform and from whom you profit from comply with the law, you think that should be a responsibility of the Electoral Commission. And only when, and I quote your presentation, persistent refusal or non-compliance with warnings would you get to an escalation. That suggests that people would be able to break the law persistently, be non-compliant. You guys would profit from it. But at some point, because of your warnings, it would escalate to the Electoral Commission, and that seems to absolve you of any responsibility for the content on your platform. So again, I don't see how having a person responsible is anything other than a natural safeguard. You keep describing yourself as an intermediary, but ultimately your company is profiting from the ads that many of us, and like Paul, I place ads on Facebook. You're profiting from the ads we place, so there should be an obligation. So maybe you can address some of those concerns, and I may come back, Chair, in the next round if there's time.
Thanks, Deputy President. I suppose just as a first point, I wouldn't see that what we're arguing for is a watering down of the provisions in the legislation. I think what we're arguing for is to make the provisions more effective, and to give the regulator the appropriate tools in which to engage with companies such as ourselves to establish the practices that are in place, and also to be able to react and adapt and to in relation to any new threats that are coming down the road. In relation to the definition of our approach to a definition of social issues and electoral political ads, like I just had a quick look at the ads library there this morning. Yes, there are ads from NGOs there. Yes, there are ads from companies that are speaking about sustainability and sustainable energy and those type of ads. We believe that is all influencing the democratic process here, and that's why we required those individuals and organisations to go through those steps and measures to put it into the ads library, so that everyone can see what the ad is, who is paying for it, the categories of targeting that were used in relation to it, what the spend range is, and other details in relation to the ad. So that, I suppose, that's the point on definition. Like the question of how is that different from what the government is suggesting. I suppose it's not clear to us what a political purpose ad is. It's one thing to say it contains content in relation to social issues, in relation to electoral issues, in relation to political issues, and that's a far more objective test than saying trying to figure out what the intention of somebody behind the advertisement is, and that's the point we're making. It's moving from the subjective into a more objective test. On the point of micro-targeting, I suppose, like, this is something, the releasing of the targeting criteria is something which has been probably the number one thing which academics have been calling for since 2016, 2017. And we have real privacy concerns around releasing the targeting criteria in the EU. But it's not the case that we're saying we have privacy concerns and we're just throwing our hands up and saying there's nothing we can do about it. We've been engaging with the European Commission for the past number of years, and with academics at the European level,